A foundational constitutional protection that is apparently baffling to certain members of Trump's team, habeas corpus has been making the rounds on the news lately. Trump's deputy chief of staff, Stephen Miller, created a stir when he indicated the regime was looking into how to suspend the writ. And the director of the Department of Homeland Security and self-proclaimed proud puppy killer, Kristi Noem, caused further controversy a couple weeks ago when she seemed unable to define what habeas corpus is under questioning by members of the Senate Committee on Homeland Security and Governmental Affairs. The reality is that a lot of people probably can't define habeas corpus in this country. Most of those people, however, aren't in charge of a major federal department actively detaining tens of thousands of people. As someone in charge of assisting the president with faithfully executing the laws of the land, who swore an oath to uphold the Constitution, a Constitution which explicitly provides that, quote, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it, Kristi Noem should, at the very least, have a vague understanding of what habeas corpus is as she rounds up humans and shoves them into holding pens on behalf of the federal government. Given the shortcomings of our failing educational system in this country, let me do my patriotic duty by defining habeas corpus for us all and giving some context behind why this writ is so consequential and why the threat of its elimination should be deeply concerning for everyone currently present on U.S. soil, citizens and non-citizens alike. In the United States today, the writ of habeas corpus gives people who are being held in prison or otherwise detained the right to challenge their detention in court. Detainees may contest their detention on the grounds that their detention is unconstitutional or based on incorrect application of federal law. Due process, the idea that someone has the right to notice and an opportunity to be heard before they are denied their life, liberty, or property, is closely tied to habeas corpus. If someone is detained and being denied a trial, that is the state detaining someone unconstitutionally without due process, at which point the person's right to the writ of habeas corpus would kick in and they could challenge their detention on the grounds that it is unconstitutional because they were denied their due process. The writ of habeas corpus has literally hundreds of years of precedent and was brought to the United States from English common law. In fact, it is the only writ from English common law explicitly mentioned and protected in the U.S. Constitution. It was included by the framers of the Constitution, having won a battle against monarchical autocratic rule. It was the monarchy that necessitated the creation of habeas corpus to begin with as a protection against tyrannical rule. At its most basic, habeas corpus protects people from being imprisoned indefinitely by the government. If you begin to consider all the reasons why an out-of-control ruler might want to imprison people, you start to understand the breadth of abuses that are protected against by the writ of habeas corpus. It protects against being indefinitely imprisoned for being a personal enemy of the ruler, as retaliation for activities the ruler doesn't like, for being poor, for being brown, for being a certain religion. It requires the state to provide a good reason for why you should continue to be detained. And while, of course, abuses still continue, because there are numerous instances a person could point to in which the good reason given by the government to detain someone was questionable at best, it's still, at the very least, requires the government to justify its actions, and it gives the detainee an opportunity to be heard before a judge on the public record. Habeas corpus is also essential to the checks and balances between the three branches of government. If the DOJ, an arm of the executive branch, chooses to arrest someone, they must go before a judge in the judicial branch to justify that detention, and it is usually based on the laws written and passed by Congress in the legislative branch that the DOJ then justifies the detention. Without habeas corpus, law enforcement under the executive branch could detain individuals without having to answer to anyone. And that's, of course, entirely the point behind why the Trump regime is looking into suspension of habeas corpus.